Okay, lovely. So welcome everybody. So thanks for everyone that's come along today in person, even despite the rain and the poor weather. And to everybody online, thank you very much for joining us. I think this seems to be an interesting session, and I hope that you won't be disappointed. Hey Richard, and all those that have joined us from across the pond as well, thank you very much. So just by introduction, so the AI revolution is underway, and it's going to be sort of a game changer for legal, I think, and the balance between safe and effective AI is pushing the boundaries of innovation, but it's also bringing additional challenges to us in law firms. So most of the firms are trying to investigate the sort of AI landscape, and I know we're doing that ourselves. It's not just about practicing law, but it's also understanding the tech behind it, what our vendors are doing, the tech behind it, where they're using generative AI, and just in general, sort of large language models. So I'd like to introduce you to our lovely panel. So we have, and I'm going to read their title, I'm not going to pretend to, I know. So Jessica Kay is a partner in the regulatory team at Kingsley Napley. So Jessica, hello.
Hi.
Emily Carter is a partner in the public law team at Kingsley Napley. So Emily, thank you for joining us. And Sarah Harris, this is slightly more longer time, is a former criminal barrister and former regulatory partner of KN and is now innovation partner at the firm. So welcome, Sarah. Thank you for joining us. So the panel will be discussing data privacy in the ever-evolving regulatory scene. So together they're going to unravel the forefront of the minds of law firms and where we are today. So please feel free to ask questions along the way. So anybody in the room, please feel free to ask questions as we go. And for anyone online, our lovely Julie is going to be monitoring the chat. So if you've got any questions, please put them in the chat, and we'll try to get to those at the end of the session, because obviously it's a bit more difficult to interrupt for the online questions. But if you've got anything here, so let's enjoy the session. For everyone that's here, we have wine and beer later. So for those of you online, unfortunately, I can't talk about that. I'm going to hand I'm going to hand over to the panel. Thank you very much.
Thanks. So where do you start on a topic that is literally everywhere you go? So we're going to start with the King, who recently, as we know at Bletchley Park, has made a number of statements about AI, that we're witnessing one of the greatest technological leaps in the history of human endeavour. And he went on to say that the rapid rise of powerful AI is considered by many to be no less important than the discovery of electricity, the splitting of the atom, the creation of the World Wide Web, or even the harnessing of fire. But AI in law, as we know, really isn't a new trend. Especially when we use that broader definition of AI, i.e. the capability of a machine to imitate human behaviour. We've all been using it for a while, e-discovery, contract automation, even things like Brighton, IOTA in the past few years in terms of decision-making automation. Lots of our wider practice management, billing software uses forms of AI, and often for legal research, we've been using it for a long time. So really what we wanted to think about was, well, what's the fuss now, and why is it really hitting legal in the way it is? And I think, ChatGPT, I'm afraid, I think was an inflection point for lawyers. I think, it was already gathering momentum as something people realised was imperative, but I think that was the real turning point. I think mainly because people used it, rather than it being a push to lawyers to say you need to use technology, it was a real pull in terms of its use. And as we know, it got to something ridiculous like 100 million active users in 2.5 months, which Instagram took 2 years to do. So it just had that real impact. And I think when people used it, and I can speak personally as well, I think you could palpably sense that game-changing aspect of it from a language point of view. And as a lawyer, previous lawyer myself, you could see where it was going to have an immediate impact, and that the up until then incremental move to digital wasn't going to quite cut it, and we needed to do something a bit more drastic. So I think the main point about it was that it was generating language, because obviously language is the currency of lawyers. That's what law is about. It's all about the language we use and the words we pick or don't pick. In law, all roads lead to documents, whether you're reviewing them, creating them, it does feel a bit like that sometimes, producing documents. It's key to the practice of law. I think that's what's captured everybody's imagination. And then lastly, I think the thing that really made an impact was the fact that it just felt like it was just unleashed on the world without a huge amount of thought in advance in relation to regulation, how we were going to do it. There was a real feeling of the genie's out of the bottle, we've got to keep up and do something. So getting to a place where we can use that and be innovative, but in a safe and effective way, I think is a real conundrum that every single law firm is going to be facing, whether they say they are or not. So during this session, the real experts are going to talk about data privacy and the regulatory landscape, and the infrastructure and risk management strategies that firms need to implement to reap the benefits of it. So yeah, over to you, Jessica and Emily.
And shall I make a start? Thank you very much. Just to explain the angle that I'm coming from,
we're just gonna pause. Yeah. We're just gonna. If you're online, can you please mute yourself? Please. Mute.
Jackie.
Yeah, Jackie, iPhone, please mute. Thank you. Thank you.
Okay.
I was going to say I
can't got the access to it. I think it's quiet. I'll make a start. So my particular angle is personal data and data protection, which is an area that I've been advising upon in a number of different contexts over recent years, almost entirely. I'm particularly interested in AI because it is going to change everything we do, obviously. And I wanted to start with the regulatory framework. This slide was handcrafted rather than created with generative AI. I have tried to demonstrate the layers of regulation that every law firm, every organization will familiar with to a greater or lesser extent. Underneath that, we have the industry-wide regulators. And the two that I've highlighted there is the Information Commissioner's Office, the ICO, which I will talk about at greater length shortly, but very much, I think, is in the front of the queue in terms of regulators that we should be paying attention to. There's the CMA as well in relation to more discrete issues with respect to competition. And then under that, sector-specific regulators, law firms, obviously, there are at least 3 separate regulators. Jess will be explaining the sector-specific regulators. Then underpinning all of that, of course, is other relevant legislation and law. And the more you think about it, the more it is evident that a variety of different areas are going to be touching on AI. Very interested in online safety, and certainly I'll mention in due course the Snapchat issues that have arisen with the ICO, and that is very much about online safety for children in particular. Modern slavery has come up as well with news reports, I think in September, with moderators, content moderators or human trainers who are training large language models in relation to harmful content, talking about the harm and distress caused to them. So issues in relation to the supply chain, potentially. Intellectual property is obviously a whole other area that causes all sorts of issues and considerations. Now, there'll be no lack of regulation, but what there is unlikely to be in the UK is a super regulator. There is currently an office for AI, but I think the consensus is that the trains, the wind,
Oh, it's probably the wind.
The wind.
I think.
The consensus is that regulation best sits with the sector-specific and context-specific regulators, which makes complete sense because AI will have completely different impact and implications depending on how and where and with who it is deployed. The regulatory model at the moment in the UK is going to be very much principles-based, all with each separate regulator having to refer back to the AI white paper principles. And the white paper sets out very specific steps which should be taken by sector-specific regulators to make sure that they are aligning with the high-level principles. I should say that, you know, a lot of the principles are self-evident and very much would be very plain on any document that you would see within any of the other regulators anyway, in terms of fairness and transparency and explainability. Finally, I should mention that this is the UK regulatory framework, but regulatory remits are not going to be country specific. It's not going to depend on where your office is based. Certainly UK GDPR depends on where the data is from, where you're offering your services to. So almost any AI, generative AI tool that depends on data from other countries or services offered to people in other countries potentially could engage the regulatory regimes of other countries. So there's a really real question that should be asked in terms of which regimes are engaged in what we're doing. And that's on top of usual issues in terms of data transfer from countries. So really complex sort of regulatory framework to be thinking about. Jess is going to talk about some of the different examples of regulation internationally.
Yeah, so Emily's really clearly highlighted that the UK approach is very much principles-based, but there are a number of ways that governments around the world, jurisdictions around the world are looking to seek to regulate the proliferation of AI in everyday life. Just to give you a bit of a snapshot, so some countries are very much looking to legislation as the way to promote the safe and effective use of AI. Give some examples. Brazil and China and the EU are taking this approach. Brazil, for example, has a draft AI bill already, which is essentially focusing on the rights of the users that are interacting with AI. And they said that they will have guidelines which will accompany that. And they're looking to categorize AI into the types based upon the risks that they think it poses to users. So that's just one example. So they're very much prioritizing the safety of the users of the AI.
Can I ask, just could you give me an example of the type of risk?
Yeah, so for example, if the EU Act, for example, they are looking to categorize it specifically into 3 types of risks. They're talking about as unacceptable, high, and then limited risk. So unacceptable risk would be something that someone was proposing that was, you know, like an immediate danger to a threat to life or likely to cause harm, for example.
AI for that purpose.
Yeah, and we've got to think about this in all contexts.
Hospital usage.
Exactly. So these legislative approaches have got to cover everything, exactly, healthcare, life sciences, law firms, literally everything, financial services. So education, everything. So the EU approach is very similar to what I've just said in terms of Brazil and China. So it's a very legislative-based approach, but very much prioritizing the safety of those that are using AI services. China's doing something similar, but it's saying with their draft regulations, they're requiring generative AI to reflect socialist core values and be designed to generate only true and accurate content, which is a really, really high bar. And they essentially, as they're currently drafted, are saying that the developers of AI need to bear responsibility for the output that their AI creates. So really quite different positions on the spectrum. So as I've said, EU Act is looking to categorise risk into those three categories. And then right at the other end, you've got countries like Japan who are saying, at the moment, this point in time, we're looking at policy development. We're not even thinking about legislation. We're not thinking about regulations. Everything is moving so quickly. We just think that there's no sense in having sort of an immediate plan to have regulations or really prescriptive rules. So they're essentially choosing to wait and see how all of this unfolds over the coming months. So they're saying at this stage, I don't want to stifle innovation really early on in the journey. So it's quite interesting. And I think what Japan has done, which touches on what Emily said about all this underpinning legislation and law, is that they've said they're going to rely on existing legislation, particularly around information law. And they've said, for example, they've got a 2018 Copyright Act, which was amended to allow copyrighted content to be used for data analysis previously. And the effect of that amendment has now been extended even further to apply to AI and the training of AI tools and training data, meaning that AI developers can train their algorithms on copyrighted content with a view to then generating more accurate data and minimizing the spread of misinformation. So it just shows you that there's a number of different approaches, from really prescriptive rules, principles based, and then right through to much more just about developing policy and just seeing sort of where we land over the coming months. So that's all I really wanted to say about that. But Emily, you were going to talk a little bit just about some of the key takeaways from the AI Safety Summit. So this time last week, 1st and 2nd of November, was the inaugural AI Safety Summit, which was held at Bletchley Park, which is a very iconic location. And it was, very much a UK wanting to be at the forefront of innovation and leading the way. We'll see how that sort of plays out further down the line, but this was the first summit. So Emily will talk about some of the key takeaways to come out of the summit and what's coming in the future.
Certainly, I think the greatest achievement was that it happened and that everybody was in a room and having the conversation. And I think that in itself met the objective of making sure that there is coordination and collaboration.
Who was invited?
I was going to ask the same
Sorry.
question.
So there are 29 signatories to the declaration, the Bletchley Declaration on AI Safety. So 29 countries.
Quite key players there as well.
Yeah. So Kamala Harris was there. A lot of leaders from other countries. There's a list online, as well as Elon Musk was there. And was at a meeting with Rishi Sunak. So I haven't seen a full list of all the attendees, but I think it was a representation of industry as well as
the big hitters.
International state.
So you kind of had China there, lots of EU representation, other parts of Asia that are really far ahead in terms of innovation. So it was really well attended, and then as you say, some kind of people out there in the tech world as well. So it was good.
And I anticipate some sort of civil society representatives as well. Rishi Sunak tweeted at the start of the summit that the intention was to achieve three things: agree on the risks of AI, and then to allow that to inform how to manage those risks. The second was to collaborate better internationally. And then the third was looking at how safe AI can be used for good globally. So straightforward in that sense. Elon Musk, as I said, was there and made it plain on the first day that, certainly from his point of view, that it was important to understand the issues before putting in place a framework, which again sounds perfectly sensible. So insight before oversight. The output of the summit was, of course, this declaration, which again uses all the language you'd expect to see in such a declaration about ongoing communication, collaboration. Right in the original, in the first paragraph, it talks about use of AI, which is human-centric, trustworthy, and responsible. So no surprises there and very good intentions. And from this point, there'll be there's an agreement for an international panel on AI safety, with analogies often drawn to both climate change, the International Panel for Climate Change, but also atomic energy is something that comes up again and again. In another 6 months' time, there'll be another summit in South Korea. And then 6 months after that, a summit has been booked in France. So it seems that this is the beginning of a process of some momentum in terms of that conversation, ensuring people are speaking a common language.
And the focus very much, I mean, the summit was called the AI Safety Summit. So there is this absolute focus on safe and, the safe use of AI. So I think that's it's really important at this really early stage.
Do you think these people learnt a lesson from when the internet was first
Who knows?
available and nobody took any notice and there were no regulatory bodies around the internet, and look where we ended up? So I think they've learnt a lesson with AI thinking.
I'm hoping so.
Actually,
Yeah.
you need to start off, so you need to go on.
Yeah, I think so. Truth will come out, won't it, though?
Yeah.
Devil will be in the
there's
detail.
a greater sense of urgency as well, isn't there? Because
I think it's the speed.
Yeah.
Yeah, it's moving so quickly.
Shall I turn to the ICO?
Yeah,
And then you're going to
please,
talk
yeah,
about
yeah.
the SRA?
So we're going into this. Yeah,
Yes, I don't.
there's nothing.
I
else
don't.
there.
I don't have another slide.
Yeah.
The Information Commissioner. So, as I think you'll all know, the Information Commissioner is an unusual regulator in that his remit is every organisation that processes data. I've never met an organisation, personal data relating to an individual. I've never met an organisation that doesn't. So everybody falls under the umbrella of the Information Commissioner. In terms of the extent to which AI involves the processing of personal data, that's quite a complex, technical and interesting issue. Certainly within the AI life cycle, personal data may arise in a number of different circumstances, including training sets, reinforcement training, including from human trainers or feedback from users, prompts. And when you bear in mind that prompts may be, please summarize this document or please translate this document and then summarize it, you are potentially feeding a lot of personal data into the model. And then finally, the output. And probably a lot of people have produced biographies from generative AI tools. So there is a number of different touch points. Personally, I think it would be very difficult to develop or use an AI model in any way that didn't engage UK GDPR and the oversight of the Information Commissioner. So in my view, important. The Information Commissioner has a pro-innovation remit, and that's going to be formally recognised within the amendments to the data protection legislation, probably next summer. But, very clear on everything that they do, that they have fallen in line with the government's innovation agenda. However, there is also a very clear appetite to regulate AI. And I think it's fair to say that the Information Commissioner has been somewhat at the forefront of tracking the different issues, including big data and machine learning, a number of years before we sort of had this earthquake in the spring. So very much, I would say the Information Commissioner considers himself right in the middle of things. The Information Commissioner's Office, along with the Competition Markets Authority, Financial Conduct Authority, and Ofcom, have clubbed together to form the, need to get this right, Digital Regulation Cooperation Forum.
Rolls off the tongue.
Yes,
Catchy.
the DRCF, which is about coordinating in relation to a lot of the areas of digital regulation, online safety, but also the use of AI. And they produced a paper, I think last year, around auditability of AI, which is a key issue. The Information Commissioner has partnerships with other sector-specific regulators in the UK, as well as very good relationships with regulators around the world now, increasingly so. And the enforcement action against Clearview AI, I think, is a really good demonstration of a new, more international approach to what are essentially global issues. So I don't know if you followed the Clearview AI story. This was a startup, essentially, I understand, with some kit to enable them to scrape the internet for images of facial images, and then using the technology, facial recognition technology, to identify the faces of individuals whose pictures have been uploaded to the app. And huge privacy sort of considerations around that. At the moment, it is only used for law enforcement across the world, but there's been action from regulators, including the Information Commissioner, I think Italy, France, Greece, Australia, in relation to the scraping of the data and the use of that data.
So basically, the application is looking at all of our Facebook profiles, LinkedIn, Instagram, finding out who people are, so that if they see somebody on a robbery,
Yes,
it'll then whiz through and come up with a
Wow.
demo.
Absolutely. Which
Start behaving yourself, sure.
within a law enforcement context, it sounds like it makes perfect sense. But if you start thinking about all the other contexts in which it could be used, it is quite horrifying.
And if it gets into the wrong hands as well.
Yeah. And as you say, it's all public data. It is literally internet scraping.
About the extent of that, just having an image of somebody coming into our building with an ID card with a picture that they've scraped from the internet, everything. That is really scary.
Absolutely.
How would your software would when they come up to the front desk, your receptionist would already know who they were. And so when the person says, "Oh, hi, I'm Sean Clayton, here's my pass," they think, "Oh, you're not Sean Clayton, you're Frank Smith," according to our AI software.
You'd hope so. You would hope so.
No, and there have been some very weighty fines. I think something in the realm of 7 million from the Information Commissioner. I saw 21 million from the Italian regulator. Unfortunately, the Information Commissioner's fine has just been overturned by the First Tier Tribunal for want of jurisdiction, using the particular words of the UK GDPR territorial sort of provisions. But there is that appetite there, and that very much joined up thinking. I mentioned Snapchat. The ICO issued their first, it's a preliminary enforcement notice at the beginning of October against Snapchat in relation to an AI bot called My AI, which sits on the Snapchat account of the user. And I pulled off the explanation, partly because I'm not a Snapchat user. It is described, if I can see it, as: My AI can answer a burning trivia question, offer advice on your perfect gift for your BFF's birthday, help plan a hiking trip for a long weekend, or suggest what to make for dinner. So it is very much designed for the target audience of Snapchat, which I think conservatively, not us, it will be 13 to 17-year-old. Realistically, there'll be plenty of kids under 13 years old. But then it goes on, and this is Snapchat's own information saying, My AI's responses may include biased, incorrect, harmful, or misleading content. Because it's an evolving feature, you should always independently check answers. You should not share confidential or sensitive information. If any of you have met a 13-year-old, you can understand the Information Commissioner's concerns. the final feature here, and I know this is a world away from what law firms do, but I think it's a really useful example of where sort of primary focus will be in terms of the Information Commissioner's concern. The other feature is all the content shared with my AI is stored until you delete it. So I think there's a self-serve retention model, which on one hand, is very sensible, but again, how many 13-year-olds are going to go in and delete their my AI conversations?
It's not the way the rest of Snapchat works either, is it? It's
No.
the opposite.
Yeah, and I didn't actually check who has got access to those conversations whilst they're sitting on the user's account. So it's not surprising first step from the Information Commissioner in any way, shape or form, because it's children, it's social media, it's sort of an alignment of two major areas of focus. There will be others. The Information Commissioner's remit is vast and they have limited resources. So I think we can expect to see those real highlight, egregious, harmful breaches being sort of come to the fore first, certainly with a view to deterrent effect and sort of targeted and proportionate regulation. So, keep an eye, but certainly it will be the first of others. That was all I was going to say about the Information Commissioner. Want to lead on with the SRA?
Yeah, so as you'll all be aware, I'm sure, the frontline regulator for law firms and all those working within them is the Solicitors Regulation Authority. So I'm going to talk a little bit about that, just in terms of what I do day to day. So Annette introduced me as a partner in the regulatory team, which I am at KN, but I essentially advise law firms on all things to do with complying with their regulatory obligations. That can be ethical obligations, it can be very technical obligations around anti-money laundering or authorization queries, but also about good and effective risk management strategies for law firms. And so within that, because of the explosion of AI, we're factoring that into a lot of advice we're giving to law firms day to day. So just thinking sort of high level approach by the SRA, I'll talk a little bit in a bit about the kind of the actual obligations that come into play in relation to the safe and effective use, promoting the safe and effective use of AI. But just to touch first on kind of the SRA's positioning on this, the UK have said, it's very much down to individual regulators, sector-specific regulators, to produce and implement context-specific approaches that suit the way AI is going to be used in their sectors. So that responsibility lies and falls with the SRA in terms of law firms. So very recently, beginning of the month, the SRA published its corporate strategy for 2023 to 2026, so for the next 3 years. And it's put there sort of front and centre, one of its key strategic priorities is listed as supporting innovation and technology. And they've said that they're committed to keeping up to date with and actively supporting innovation and technology that improves the delivery of legal services and access to them, particularly for individuals and small businesses, as well as supporting all firms, but trying to help small firms to use technology effectively and safely. So the SRA has said it's committed and wants to lead the way in terms of understanding and responding to the opportunities that are there, and also understanding the risks of technology, particularly generative AI. And they've had this for a while, but they're sort of putting much more of a focus on it, particularly with possible tools around generative AI, but having a regulatory sandbox. So as I say, that has been there to promote innovation, but there will now be much more of a focus on innovation that's using generative AI. And essentially with that sandbox, it will be a safe testing environment, hopefully bringing together law firms, but also tech firms, so tech startups, etc., to allow firms to be able to test, to develop, and really importantly, evaluate innovative or technology-based approaches to delivering legal services. And as I've said, with a real focus on access to justice and also supporting small firms to be able to develop tools in the same way that big law can. So just in terms of, so that's a kind of high-level SRA corporate approach. But I think it's quite important. I don't want to get too bogged down in the detail because, regulations are not that exciting and not that interesting, but I think they are quite key to this in terms of thinking about law firm risk management. So as you're probably all aware, the SRA set ethical standards, but they also set professional conduct standards. And I think these will very much extend to how AI is used safely. So looking at this very briefly, there are a whole host of other requirements within the SRA standards and regulations. They were introduced in November 2019. But for the purposes of this session and for a lot of things more generally, I like to think about the trilogy between the principles, the codes, and then the SRA enforcement strategy. So for me, the SRA enforcement strategy is a bit of a linchpin to the standards and regulations. It sets out not just how the SRA might enforce something when something's gone wrong in a law firm or in relation to individuals working within a law firm, but it also sort of sets out their thinking around decision-making processes. And that's why I think this is really important in terms of the use of AI, and I'll talk about this in terms of practical considerations. AI and how your law firms use it, whether that be something that's client facing or something that's internal, is all going to be underpinned by really key decisions and about assessing risk. And the enforcement strategy talks about mitigating factors being around being accountable, being able to explain why you've taken certain decisions. So I think this is an absolute key component of risk, law firm risk management. The principles, I've got another slide in a minute, but I also like to flag that the principles are really, really important within the regulatory framework for law firms, because the principles apply to everybody working in a law firm. So they don't just apply to qualified lawyers, they apply to anybody working within your firms. That could be your head of IT, that could be your head of finance, it could be your operations director, it could be your trainees. Absolutely everybody working within the firm has to comply with the SRA principles, which are the tenets of ethical behaviour. And so it's through that we have to kind of think through that lens, think about risk management strategies around the effective use of AI, because the principles will capture the conduct of everybody within the firm. The codes relate specifically to professional standards, which then relate to solicitors working within your firms. But I think it's quite important to remember that the principles do apply to everybody, and that's how law firms are captured within the broader regulatory framework. So as I've said, the principles are all encompassing. They apply to everyone within firms. They apply inside and outside of law firm practice. They apply in your private life as well. Not relevant to this session, but I always think is quite eye-opening to kind of to make that point. So they are really, really important. Just in terms of the ones that are most likely to come into play in terms of using AI safely, principle 2 is about upholding public trust and confidence. So everything you do has to uphold public trust and confidence in the profession. Again, this goes back to decision-making principles. How, as a law firm, will we roll out AI? How will we make sure everybody understands how to use it? We want to be the first ones to the market with this amazing product. Are we doing that with integrity? Are we cutting corners? Emily will talk about this in a bit, but in terms of data protection, client confidentiality, are we doing things not as well as we should be? We have to think about client data and personal data as well. So these are the 3 principles out of the 7 principles that there are that are most relevant to the safe use of AI. Coming on to the codes, so these principles, as I say, would capture everybody. Coming on to the codes, I think the most important point is to kind of emphasise that this is about competency. So this is about your lawyers in your firms understanding the tools that they are using, whether that be internal facing tools to do research or automated processes such as client due diligence, through to tools that you might be producing and developing as a firm for clients to use. So ultimately, everything is about the competency requirements in the code. And our competency requirements in the SRA code are very general. So interestingly, in the ABA code, so the model code that's then adopted into various states in the US, they have a competency requirement around being technologically competent. So we don't yet have that, but we have this paragraph 3 in the code for individuals. Paragraph 4, there's a code for firms. So you've got a code that applies to law firms. This is about our services to clients having to be provided competently. And interestingly, you have to be able to carry out your role, keep your professional knowledge and skills up to date, and including of those of anybody you're supervising in your organisation, making sure they are keeping their skills and also understanding of all of their obligations in terms of legal obligations, ethical and regulatory obligations up to date. And again, playing into the client element, there's a need to consider and take account of a client's attributes, needs and circumstances. So you will need to be thinking about this when using AI, that all of these things have been taken into account. And I'll talk about this in terms of promoting an effective and safe use of AI, but supervision plays a hugely important role in this, that people understand the tools and understand the impact that they might have. So they're the main provisions relating to individuals, but also there is that competency requirement for firms as well, making sure everybody within the firm is doing everything they can to provide services competently. And then very specific to law firms requirements, and this plays into the whole risk management piece more broadly in terms of the practical considerations. But this is about having effective governance structures, arrangements, systems and controls in place. And really importantly, paragraph 2.5, which is about identifying, monitoring and managing material risks to your business. So that would include any risks around the balancing of how innovative AI can be, but also balancing that against the risk and very much feeding that into your risk management strategies as a firm. And that's all I wanted to say on that. But I think it's really important, a bit dull, but important to understand the actual regulatory requirements that exist for the lawyers in your firms, but also everybody else working within the firms, to really understand that using AI, using tools, all of these things is actually no different to other decision-making process that you go through every single day as a lawyer. And I think feeding that into the risk management piece, which I'll talk about in a bit, is really, really important.
And does that responsibility sit with the risk management team to enforce? I mean, how are firms enforcing that? Because I don't think we have much.
I have many questions about that.
I know.
That's fine.
I mean, it's
How do you
difficult.
supervise them? How you train them? What are the main threats in the short term that we face?
Yeah, I've got, so there's a section coming up about all the
perfect.
practical
Okay.
risk management side. But in relation to your question, Annette, yes, some of it has to sit with your risk and compliance. Each firm will have a compliance officer for legal practice and one for finance and administration. They might be your GC, they might be your head of risk, they might not be. They do have a certain amount of responsibility, but equally, it's when you come down to the specific requirements in relation to individual lawyers, they have those obligations themselves. But it is about the firm, not necessarily the risk and compliance team. It's got to be not working in silos. It's got to be your HR team, it's got to be your training team, it's got to be your IT team, it's got to be your risk and compliance team, taking a really joined up approach around training. There needs to be a huge amount of training, and making people aware of what their own regulatory obligations are. So we deliver training to firms covering all of what everyone's regulatory requirements are.
They're already there. Despite the AI stuff.
Oh, this is it. This is what I mean. They're there.
Just reminding them
Yeah,
that
and these will apply.
AI falls within this as well.
Yeah, and they will apply to AI in the same way that they apply to sexual misconduct or breaching the anti-money laundering regulations, or
I wonder if that really is true, because every time I mention AI, everyone glazes over. It's like it doesn't belong to me. It's not. This is your problem.
Yeah.
Like, not sure it is my.
No, it isn't. It's bigger than that. And I talk often. It's a bit cheesy, but ultimately, compliance. This is my own thinking, but compliance is culture. Compliance has to be woven into your firm's culture, into all of your kind of how you make decisions. It's big piece, and it has to come from the top down. So, yeah. It's me next, isn't it? Or
Yeah.
Sorry,
Unless-
no, it's fine. So I've talked about the dull part of the regulation, but ultimately this is about how it plays into the practical. So essentially, I'll go round this, but I'll sort of some bits will overlap. But for me, this ethical framework for decision making is absolutely crucial. This has to be in place in relation to your risk management strategies for everything. So you could be making a decision about, do we take this client on? Is it a good client to be taking on for whatever reasons? How effective are our due diligence systems and processes? Should we be using this tool for AI? Should we, does this feed in well to our automated processes for something specific? Do we want to generate a tool that we put out to clients? It underpins everything. It has to be part of your culture. So it kind of fits in with the one above. The compliance has to be part of your makeup of your firm. It can't be an afterthought. It's got to be woven into everything that you're doing and into the services that you are providing. So effective policies, just a word on that. Who knows what these policies are going to look like? I presume I'm sort of working on the assumption at the moment there are probably not policies in place for safe and effective use of AI. It's very, how granular would they need to be? It's very difficult. They've obviously got to have flex built into them. The UK's approach is very principles based. It has got flex in it, so these can't be rigid. All I would say, like, to make a policy effective is that it's living and breathing document. It's not something that you have. You?
I think so, yeah.
That's really good.
I think so.
Yeah.
I'm pretty sure we have.
We have some in-house AI tools.
Yeah.
I can't imagine people have put those out to the firm without
Yeah.
something in place.
And people have got sort of statements of policy around use of ChatGPT and things, haven't they, in the office as well? So there are certain things like that.
Have a statement about that.
Yeah.
Very minimal.
Alan Overy username when you're signing up for it, not to use it for anything business related.
Yeah.
We've had all of that kind of information.
Yeah. So I think these policies, but I think they need to be there. They can't be too rigid. They've got to have flex built into them, and they also need to be at this point in time need to be revisited really regularly, and not just some policies. I'm not saying in relation to AI, but other policies just get written. Nobody ever looks at them. They sit on the shelf gathering dust. In the kind of not in the literal sense these days. But I think it's really important they are just continuously reviewed and tweaked as they need to be. So coming back to your point about how do we make everyone aware of this, training is absolutely essential. And I think to make training effective, it basically needs to be something that people are accountable for. So have action points coming out of your training. Don't just sit people in a room and expect them to listen and then go away and not actually do anything. So try and have some sort of tangible action points coming from your training. And ultimately, it's about getting staff to a position of understanding what your firm's core values are. And that will be different for all firms. And trying to create, this goes back to the ethical decision-making thing, but trying to create within everyone their own kind of ethical gut or moral compass. And I think that needs to be woven into training of all sorts, and it feeds into our general conduct within law firms as well. And what we found really good is it sort of very practical case studies work for training really well, and also throwing in a few horror stories. There's nothing that seems to be more effective than kind of showing where things have gone wrong, really getting people to sit up and pay attention. So that's something to think about in terms of training. And again, supervision, again, this feeds into risk management, law firm risk management strategies generally, but making sure that there will be people that need to be taken on the journey with generative AI. It won't just be junior people as it is with other types of law firm risk management issues, but people that might be more resistant to change, people that think actually this is not a big deal, this doesn't impact me, like you're saying, just glaze over. It's about having effective supervision in place that those, also from a risk perspective, if you think there are people that are just not going to take any notice, thinking about if they need to be supervised more. closely as well. I just threw in cognitive diversity because, again, this to me comes into the sort of the enrichment of decision-making processes. Just really think about the people that are in the room, again, not in the literal sense, but who are there as part of the important decisions that are being made. With cognitive diversity as well, think about the risks of things like groupthink. If everyone just all gets on the bandwagon because there's one person potentially that's more influential than others when it comes to decision making, and that person sort of steals the limelight in the room and pushes people in certain directions with decision making. I really like the term hippos as well, which are the highest paid person's opinion. So be alert to those people as well, or the sunflower effect, where people kind of gravitate towards that person because they think they've got a lot of gravitas. So they're just sort of simple, practical things to think about. And as I said, all of this feeds into overall law firm culture and your core values. And having robust systems and processes is directly going to follow into what Emily's going to say in terms of actual information and privacy law considerations. But they need to ultimately be stress tested. That's how you know that you've got robust systems, is by stress testing them. So that's just some sort of practical considerations. But if anyone's got any questions, I can take them now, or we can listen to Emily and then we can take them after that.
I will continue later.
Okay.
Yes.
You think you're getting an easy drink.
I'll happily have a conversation over the wine.
Yeah. I see we're probably getting close to an hour now. Are we okay? Yeah?
Yeah.
Fine, good. I think we missed the trick. We should have generated an image of a hippo with some sunflowers.
Oh,
next
yes,
time.
yeah.
Next time we'll do that.
Be intriguing. UK GDPR, I'm a big fan. I know that a lot of people aren't necessarily as enamored with it as I am. I'm not going to make this GDPR 101 because we all did that in May 2018. I'm just going to draw out some of the more interesting aspects of trying to apply that law to what is happening now. First thing I wanted to say is it's a really, really useful, more granular framework for safe and effective decision-making in relation to anything to do with data, but AI in particular. Partly because the principles are fairly robust, but there's also a lot of guidance, and the Information Commissioner has issued a very long guidance note on AI, which makes for quite interesting reading if you like that sort of thing. First thing is GDPR was always intended to be future-proof and technology neutral. It is succeeding to an extent, but I am observing a little bit of sort of stretching and creaking around the edges, and a slightly different terminology being used by the Information Commissioner in his guidance. The key issues I wanted to highlight in that sense are, first of all, the emphasis at a number of points that when you are looking at the rights of an individual, which is one of the key balancing sort of issues when you're using data of clients, suppliers, witnesses, advisors, you're not just looking at their privacy rights. And it's obvious when you read it, but it's about rights and interests more generally, the right not to be discriminated against, the right to the same opportunities that other people have, the right not to be harassed because, of who you are. So it's not just privacy. Second thing is accountability is one of the big issues, completely sits full square with what Jess has been describing within the context of a law firm. Data protection impact assessments are essentially just risk assessments around the use of data, and there's really good guidance about how to do that. Privacy by design, making sure you think about it from the outset and build the privacy in, is again a really essential part of accountability. A change to the law that we will see, I anticipate next year, is data protection officers will be done away with, or the requirement for a data protection officer will be removed. And for certain organizations with high riskier processing, they'll require a senior responsible individual, which is, in keeping with other regulatory schemes, but it's very much designed at senior responsibility, boardroom responsibility. So helpful, I think, that is the change in the model. Security is identified as being increasingly complex and challenging in relation to AI models because of the number of other controllers, suppliers, hosts that may be involved. Keeping an eye on where the data is, in what form, at what time, across organizational boundaries, having the right contracts in place. Really, really important. Underpinning everything is fairness, and fairness, tying back to this idea of rights and interests, is about making sure that what you do aligns with people's reasonable expectation, and that processing doesn't have any unjustified adverse impact. And that's the standard definition. But you can imagine a world where client data, other data in the hands of a law firm is being used for the purposes of developing AI outside of what is reasonably anticipated by the individuals concerned, which brings in two of the more difficult areas of applying UK GDPR. One is transparency. So there really are prescriptive requirements in relation to transparency, and it's quite tricky to imagine deploying those in the context of AI, given that the requisite notices are meant to be available or provided at the point the data is collected or when the purpose of that data changes. So quite challenging. And, I look at it and think, yeah, I can see how that might not happen in practice. Second issue is individual rights, subject access requests, which is difficult in everybody's life already, but when it comes to subject access requests within the context of any form of large language model, practically incredibly challenging. The ICO provides no real sort of guidance or practical advice there. Inaccurate data to be rectified or indeed deleted. Once data is learned and embedded, it's going to be incredibly challenging to see how those requests will actually be implemented. I think in reality, more of a concern for OpenAI than a law firm, but potentially something to keep an eye on. The final thing I wanted to say about UK GDPR, the language, again, has moved to the idea of considering trade-offs within the risk assessment, which isn't something, a term I'd sort of observed before reading the AI guidance. Very, very plainly, it is written that you're not required to take a zero risk approach, which has got to be right anyway, and that there will be certain tensions that need to be borne in mind. And the example that's often given is around data minimization, not just accumulating huge amounts of sensitive data for the sake of it, whereas for a lot of models, the fairness and accuracy of those models will be enhanced greatly by having more data, and interestingly, special category data or data relating to people's protected characteristics may indeed feed into those models being more fair in their operation and output. So, there are tensions. Another interesting aspect of the guidance to draw out before I'm going to pass on to Sarah is that a bit of a theme about the Information Commissioner commenting that just because the technology is available doesn't mean it should necessarily be used. So in considering the risks and the trade-offs, to always be thinking, is it necessary? What is the purpose? Is that purpose justified when you consider the impact, which is a really interesting issue when you think about access to justice. I don't know whether that's something you've been thinking about, Jess, in terms of the use of AI within law firms, but really interesting from my perspective. I'm going to stop there.
That's great, thank you.